One viewer said this was premeditated murder. Another said the moment she stepped out of the car with a gun, she became the aggressor. Another said simply having the firearm in her hand was already illegal. And somebody else told me my legal analysis came from Google. So I went back and checked the statutes, the case law, my law enforcement background, and the actual legal elements to this case. And here's what's interesting. One of these comments gets much closer to the real problem, but several others make claims that Florida law simply does not say. So let's test them. These comments came from our discussion of the Walmart parking lot shooting that we filmed a couple of weeks back. And I'm not doing this to dunk on anybody. Some of these comments raise legitimate issues, but there's a difference between a fact that matters and a fact that automatically proves a crime. That distinction is going to matter throughout this entire case. So let's start with the homicide. Comment 1, if she waited for him to come out of that store, then that's premeditated murder and self-defense is out. This sounds powerful, and the waiting could absolutely matter, but the conclusion goes too far. Florida's first-degree murder statute requires a premeditated design to effect death. So the important question isn't simply, did she wait? The question is, what does the evidence show that she already decided to do? And this is where everything lies, because those aren't the same thing. Maybe she waited because she intended to confront him. Maybe she expected the argument to continue. Maybe other evidence was that she had already formed an intent to kill, and that may be possible. Or maybe the evidence established something completely different. As investigators, we would like to go ahead and build a particular timeline, and it will show us everything that we need to see. Waiting can be evidence of intent. That's true. Waiting can damage credibility. Waiting can become extremely important when combined with other evidence. But the act of waiting does not by itself automatically establish premeditated murder. And there's another problem with the comment. It says self-defense is automatically out. Florida's deadly force statute focuses on whether the person reasonably believed that deadly force was necessary to prevent imminent death, great bodily harm, or a forcible felony. Previous decisions can affect that analysis. I'm here to tell you. Provocation can affect the analysis. But we still have to examine what happened with the force that was actually used. So my verdict is it's relevant evidence, not automatic murder. Okay. So that's with comment number 1. And that's the important fact to this. It's just too absolute of a conclusion. Comment number 2. Okay. You misrepresented what happened. There was no continuing conversation or confrontation when she stepped out of the car with her gun. She exited to escalate. Now, this comment is a little bit stronger because it attacks the timeline, and the timeline matters here. If the first confrontation was completely over and he went into the store, she was safely inside her vehicle, and she then chose to get out while armed, I absolutely want investigators asking why. But here's where we have to separate the two questions. Was getting out a bad tactical decision? Possibly. Did getting out automatically make her the initial aggressor under Florida law? No. Florida's aggressor statute uses a much more important word. It uses the word provoke. It addresses a person who initially provokes the use or threatened use of force against themselves. It doesn't establish a rule that says whoever gets out of the car first is the aggressor. And it doesn't say if you could have driven away, you automatically lose self-defense. In June 2026, Florida's 2nd District Court of Appeal again dealt with the initial aggressor framework in Cordell versus the state. The focus remains on conduct that could support finding the defendant provoked the use of force, not tactically. I have a very different answer for you. If I'm safely inside a vehicle and I got a barrier between myself and an angry stranger, and the entire thing started over a parking space, I'm not surrendering that advantage unless I have a very good reason. Don't move toward a confrontation if you can safely avoid it, right? But here's the distinction. A tactically bad decision is not automatically a criminal act. So my verdict here is bad tactics, possibly, automatic aggressor, and we're going to have to come back to this provocation because one of the later comments gets much closer to the real issue. Comment number 3, open carry means you don't have to conceal the gun, but you still have to carry it in a holster or your waistband. Having a gun in your hand is considered displaying or brandishing in the state of Florida, and it's against the law. Now, this comment would have sounded a lot stronger before September 2025, but that all changed because Florida's open carry landscape changed. In McDaniels versus the state, Florida's First District Court of Appeal held Florida's general prohibition on openly carrying firearms unconstitutionally. Florida's Attorney General then issued the statewide guidance addressing lawful open carry after the decision. So the old blanket statement that you usually would hear is you can't openly carry a handgun in Florida. It's no longer an accurate description of Florida law here. But here's where this comment raises an important issue. Open carry and threatening somebody with a firearm are not the same thing. And I need to show you the distinction. And I wanted to separate this for several reasons that people keep combining, and they carry, display, threaten, point, fire. Those are not legally interchangeable actions. Florida's improper exhibition statute addresses exhibiting a firearm in the presence of another person in a rude, careless, angry, or threatening manner when the display isn't necessarily self-defense. So the question isn't simply, was the gun visible? The question becomes, what was she doing with it? How was she holding it? Was it pointed? Was it being used to intimidate? What was she saying? What was the other person doing? What was the distance between them? What happened immediately before that moment? Those details matter because possession of a firearm is one question. The manner in which that firearm is used is another. So the verdict here is open carry law changed. Threatening display, different question. And that takes us directly to the comment that gets much closer to the real legal issue. Comment number 4. In Florida, that's aggravated assault. She has committed a felony right there. She parked, armed herself, and waited for him to return. This is the comment I would take more seriously. Not because I'm declaring aggravated assault from a video clip. I'm not. But because this commenter is focusing on something much more important. How was the firearm being used before the shooting? That's a legitimate investigative question. Florida's improper exhibition statute specifically addresses displaying a firearm in a rude, careless, angry, or threatening manner. And Florida initial-aggressor statute becomes extremely important if the evidence establishes that somebody provoked the use or threatened use of force against themselves. So imagine two completely different videos, okay? I want you to look at it like this. Someone gets out of the vehicle, the firearm is down, no threat is made, and another person suddenly moves toward them in a manner that creates an imminent threat. Now imagine this. Video number 2. Someone gets out during an angry confrontation, uses the firearm to threaten another person, points it, challenges them, and deliberately escalates the confrontation. Same firearm, completely different facts, potentially a completely different legal analysis. And if the evidence shows that she actually provoked the confrontation, then we go into section 776.041. It becomes critical for the law, limits the justification available to someone who initially provokes the use or threaten the use of force, subject to exceptions contained in the statute. That is a legitimate legal issue. But here's what we cannot do. We cannot decide the entire case by stopping the video at whichever moment supports your mind and our conclusion. So one side freezes the video when she gets out of the car. Another freezes it when he approaches. Another freezes it at the moment she fires. That's not enough. The beginning matters. The escalation matters. And the moment deadly force is used matters. You don't freeze the video at whichever frame proves your side. You build the timeline. So the verdict on this is the real question. Did she provoke it? That doesn't answer whether the shooting was justified, but that's a question investigators absolutely need to answer. Comment number 5. Your legal knowledge is from Google. She had no business getting out of the car with a gun, period. At that moment, she is the aggressor. Stay in your car, lock the door, and call 911. Start reading more. So this might be my favorite comment because part of it is advice I strongly agree with. And part of it claims Florida law automatically does something that it doesn't. Let's take a look at the good part first. Stay in your car, lock the doors, and call 911. Tactically, I agree with you. If you got a safe barrier between yourself and somebody who's angry over a parking space dispute, why surrender that advantage? It's careless, it's stupid, it's reckless, right? Stay behind the barrier if you safely can. Lock the doors, create distance if it's safe, call law enforcement if there's a legitimate threat. Don't use a firearm to win an argument. Don't display it just to make somebody comply with you. And don't walk towards unnecessary conflict simply because you believe that the law might someday say that you had a legal right to stand there. Because there's something people routinely misunderstand about stand your ground. A legal right not to retreat is not tactical advice telling you not to retreat. Those are two very different things. The law may say that under qualifying circumstances, you have no legal duty to retreat before using justified force. That doesn't mean retreating safely is a bad decision. Sometimes leaving is the smartest tactical move available. But then this commenter says at that moment she is the aggressor. That's where I disagree. Again, show me the automatic rule in section 776.041 that says exiting your vehicle makes you the aggressor. It isn't there. The statute asks whether the person initially provoked the use or threatened use of force. And determining that requires evidence. What did she say? What did he say? What does the cell phone video capture? What did witnesses hear? How was the firearm being held? Who moved toward whom? Did anybody make a threat? What happened immediately before the shooting? Those facts matter far more than you think. She stepped out, therefore she's the aggressor. And this is why the audio matters too. The cell phone recording matters. The surveillance footage matters. The witnesses matter. The 911 calls matter because a silent 10-second video might show you part of what happened without giving you enough information to explain why it happened. So the verdict here is good tactical advice, legal conclusion here. It's too absolute. And I didn't get that from Google. Just wanted to let you know that. So let's remove the courtroom for a moment and forget statutes, forget the prosecutors, forget who's going to go ahead and win this argument online. Let's talk about the outcome we actually want. Two strangers are angry over a parking space, okay? One person has access to a firearm. Here's the outcome I want. Nothing happens. That's the win. Disengage. If you're safely inside the vehicle, stay behind the barrier, lock the doors. Create distance if you can, safely, if you can do it. Call 911 if someone is legitimately threatening you. And another thing, give dispatch your location. Describe what's happening and let the confrontation end. Don't use a firearm to settle an argument. Don't display one to gain compliance. Don't try to teach another person a lesson. Don't move closer unnecessarily to danger because you're convinced that you're legally entitled to stand somewhere. Because being legally permitted to remain in a location does not mean remaining there is tactically intelligent. And having the legal right not to retreat does not mean you should never retreat. Sometimes the best tactical decision is also the least dramatic one. Drive away, go home, let everybody live. So after going back through these 5 comments, here's where I land. Comment 1 raised an important fact. If she actually waited for him to come back, investigators should absolutely examine why. But waiting is not automatically premeditation. Comment 2, challenge the timeline, and that's fair. Leaving the safety of the vehicle may have been a terrible tactical decision, but getting out does not automatically make somebody the initial aggressor. Comment number 3, raised the firearm itself. Florida's open carry law changed after McDaniels, but that doesn't mean every manner of displaying or using a firearm is lawful. Carry is one issue. Threatening is another. Comment number 4. This one gets closest to what I think is the real legal question. What happened before the shooting? Was the firearm simply present, or was it being used to threaten, provoke, or escalate the confrontation? And that's significant. And comment number 5 gave some of the best tactical advice in the entire discussion. Stay in the car, lock the doors, create distance, call 911. I agree with that. But good tactical advice and the elements of a criminal statute are not the same thing. And that's the larger lesson here. We don't decide whether a shooting was justified because we like the shooter. We don't decide because we sympathize with the person who was shot. We don't decide it's because it's a YouTube comment that gets 500 likes. We build the timeline. We identify the evidence. We identify the law. And then we apply one to the other. Don't freeze the case at whichever frame proves what you already believe. Follow the evidence. And if the evidence changes the conclusion, then the conclusion should change. You challenge the analysis. I test it, and the evidence decides. That's what we do here at Hill of Justice. I'll see you on the next one.
This is the Hill of Justice.